Counsel for the appellant may now proceed.
Mr. Chief Justice, may it please the court, Gary Caldwell for Mr. Avsenew. There are a lot of issues in the briefs, so I would like to focus on the first issue as to penalty, as to issue number 12, which I think is dispositive of all of the penalty issues. And if I have time, I'd like to talk about issue number 3. As to issue number 1, and Coy versus Iowa, Justice Scalia, writing for the Supreme Court, wrote that the Confrontation Clause guarantees the right to meet the witness face to face. In that, he quoted various items, including Shakespeare, to mean face to face, is what confront means. He looked at the meaning of the word. Subsequently, in Crawford versus Washington, the Supreme Court looked to Noah Webster's 1828 dictionary to define the terms of the Confrontation Clause. And that dictionary defines confront as, and I quote, to set face to face, to bring into the presence of, as an accused person and a witness in court. That's the right that we're saying that Mr. Avsenew was deprived of in this case. I don't think there's any dispute about the fact that the state argued below, and the judge found that this particular witness, the defendant's mother, was an essential witness in the case. She was not able to come to court to testify, apparently. Nonetheless, the defense contended that he had a right under the Confrontation Clause to face her in court. The judge denied that. They renewed the objection at the trial. Her deposition to perpetuate testimony was taken, and I think in the brief I've tried to show graphically with pictures from the video that the mother was not able to see the defendant because of the way that the setup was made. And the defense attorney asked her if she was able to see the defendant, and she said no. Therefore, this is a violation of the Confrontation Clause of the defendant, and that the testimony of this essential witness should not have been heard by the jury. She provided a lot of very important evidence for the state, and for that reason, we contend that a new trial is necessary. So that's our first issue. The issue number 12, which is the penalty issue, which I think is dispositive, arises as follows. The prosecution sought a death penalty in this case under section 921.141 Florida statutes as amended in response to Hearst. And that statute applied retroactively to this defendant, even though the crime occurred prior to Hearst. And that statute specifically provides that a death sentence may be sought by the prosecution only on the basis of aggravating circumstances to which the state has provided notice under 782.04 parenthesis 1 parenthesis B, I believe. So the state has to comply with the 782.04 provision. Now the state says that they don't have to comply with the 782.04 provision, that it does not apply retroactively. But of course, that provision is part and parcel of the 921.141 anti-Hearst statute. If the one doesn't apply retroactively, then the other doesn't apply retroactively either. So they can't be a death sentence in this case. So what happened here was the statute was passed, 782.041B, with the notice provision saying, okay, state, you have 45 days to file this notice. And the state didn't do that. They waited 6
But
months.
by the terms of the statute, correct me if I'm wrong, but by the terms of that statute, that 45 days, that if you're going to apply it, it would have long ago passed before the statute ever came into place, right?
Right. Well, right. I think that the reasonable the question is, that the legislature mean it to apply to pending cases, and I think it's clearly they applied that because it was all part of one statute with 921.141 to apply retroactively to save the cases that were pending at the time of the Hearst decision. So the obvious solution is they have to do it within 45 days of the effective date of the statute. I mean, or alternatively, they could say, well, look, we couldn't do it within 45 days because it wasn't required, so let us do it now. And they didn't do that. They waited 6 months, and then they, finally filed it, did not seek leave of court of any kind. And then after the jury is selected, they come in and they file 2 more aggravating circumstances without seeking leave of court. So I submit to you that this issue number 12 disposes of the death penalty issues in this case, if you need to reach them, if you don't reverse a new trial. Although I think even then, the state shouldn't be able to seek a death penalty in this case. The third issue in the case, which I'll speak about briefly, concerns some telephone calls, or actually one telephone call, excuse me, in which the defendant participated. He was acting as an intermediary with another inmate who was talking to his girlfriend. And well into the call, when they're talking about some emotional issue, the defendant says, I can't believe I'm talking about this emotional issue like this. I'm a stone cold killer. This phone call apparently took place 7 years after the indictment of the defendant in the alleged crime. And I submit to, and the state says, well, obviously he was talking about this particular murder. I would submit to you that if this afternoon I say to someone, I'm not any good at oral arguments, they'll understand I'm talking about today. But if 7 years from now, I say to someone, I'm not any good at oral arguments, there's no way it's just not reasonable to infer that it has any relationship to what we're doing here today. There's no nexus between this statement and the alleged crime. Now, the state also argues that it's harmless, but I would submit to you that the court should view with the greatest skepticism for the state to come in front of a jury and to repeatedly point this out to the jury that he says is, it tells you all you need to know, the state told the jury. And, in terms of the theater of the trial, it really rubs it in for the jury because the trial is stopped. They read a special instruction by the judge about the transcripts. They have the transcripts, so they see the words and they're hearing the words. Any teacher will tell you a multimedia presentation will drive something further into the mind of the pupil, if you will. And a trial, to some extent, is a matter of teaching the jury to see things from your point of view. So I would submit that the court should not accept the state's argument that this is a harmless error.
If I can,
yes?
Can I come in for a second here? Moving ahead a little bit to the HAC aggravator.
Yes, sir.
Here, as you know, we have 2 victims. There was Mr. Adams and there's Mr. Powell. Apparently, Mr. Powell, according to the medical exam, was shot twice in the back of the head. So it is likely that he probably didn't see it coming. Now, as to Mr. Adams, the state theory is because the police found some cereal spread all over the place in a mall And they surmised from that that Mr. Adams must have been eating a bowl of cereal in a small room next to the living room. And he heard Mr. Powell being attacked and jumped up from the table to help Powell and was himself attacked. The only evidence of that is the fact that they found cereal spread around in a bowl, and it looked like it was dropped and the cereal came out of it. That's the only nexus between that and the state's theory. Now, can you talk to me a little bit about HAC here, whether that was appropriate for the jury to find or for the court to consider HAC under those circumstances? And by the way, I believe Mr. Adams was shot, 8 times or 9 times? But both victims also suffered blunt trauma to the head. In fact, I believe Mr. Powell's skull was fractured. So obviously they were beaten. However, the medical examiner could not say which came first, blunt trauma, or any medical examiner also testified that the gunshots, each shot was lethal. So either one of those shots could have killed them. So can you address that issue?
Right. This court has held long since. We had these struggles about the meaning of the heinousness circumstance in the 80s and in the 90s. This court finally resolved it. At some point, it was the view was that a murder is especially heinous, atrocious, and cruel if it's basically what we now call CCP. That is, it was cold and calculated. But subsequently, it was decided that the focus is on the suffering of the victim. And so if it's an instantaneous death or a near instantaneous death, then the circumstance doesn't apply, because every murder case is horrible. The testimony of the medical examiner is always very emotionally upsetting. If the issue is the suffering of the victim, then if there's little time or no time to realize what's going on, to form, if you will, fully formed conscious awareness that one is about to die, then you definitely have to question it in this case, because the state has very powerful emotional arguments in this case, but the question is, where's the proof? We just don't know. It's just a matter of, if you will, it's reaching a conclusion that this is especially heinous, atrocious, or cruel, and then looking for some evidence from which a narrative can be formulated to try to establish the circumstance. And I submit that that's not the right way to go about determining an aggravating circumstance in order to sentence someone to death. So in a nutshell, that's our argument on that circumstance, Justice Lavardi. So I think I've covered everything that I wish to cover. As I say, there are a lot of other issues, but we really don't have time to talk about all of them today. So I will turn the camera over to my friend on the other side. And thank you very much. And I ask that the court reverse the conviction and sentence. Thank you.
Counsel for the state, you can proceed.
May it please the court, Lisa Marie Lerner with the Attorney General's Office, representing the state. Going to the issues that Mr. Caldwell spoke on, the perpetuated testimony of Avsenew's mother, Jean, it was not a violation, of the Confrontation Clause. It was clearly within the exceptions carved out under Maryland v. Craig and this court's Herald decisions, given the fact that it's undisputed that she was undergoing cancer treatment for a brain tumor and could not travel. Her testimony was perpetuated. It wasn't really a deposition, it was a testimony. She was in a court, she was given the oath. Both sides could question her. She was subject to cross-examination, and both the judge and the jury could observe her demeanor. And most importantly, for this particular issue, Mr. Avsenew could see her. It's his right to confront the witness, not her right to see the defendant. All the elements necessary for a successful confrontation of a witness were present: the oath, the cross-examination, and the ability of both the jury later when they viewed the videotape and of the court during her testimony could observe her demeanor in order to assess her credibility. So
would it have been, do you think we have a different case if he could not have seen her on the video?
You would have a different wrinkle in it. However, I think that even in that case, given the fact that the jury could see her and assess her credibility, and his attorney was fully able to cross-examine her, that the confrontation element would have been met in that case. However,
So I just want to make sure I understand the limits of the state's position. So the state's position is then that you could have a video link where neither the accused nor the witness see each other. But as long as the jury and the judge can see both parties, that satisfies the confrontation clause?
well, and his attorney would be there, and the attorney could see the witness. As I said, that is a bit more problematic. However, I do believe that that would, in certain very limited circumstances, perhaps, a child sex victim or something, that could meet the parameters. However, thankfully, that's not the case in this situation. Going on to issue number 12, as Mr. Caldwell pointed out, the arraignment in this case happened in 2011. The new statute after Hearst came out in 2017, there's no way the state could file a notice of intent to seek the death penalty and outline the aggravators at the time of arraignment. This particular law was not retroactive. The arraignment had already happened. They couldn't undo or redo an arraignment in this case. In terms of the rest of the statute applying, the events that hadn't happened yet, jury selection, the jury weighing the aggravators and making findings, since those events of the trial hadn't happened, this new statute, of course, applied to those. And the state did amend its notice. It gave notice after the new statute was enacted. And as Mr. Caldwell said, it was several months after the enactment, but they did give notice. And then they amended the notice to include the aggravators, which all the parties knew, the fact that he was on felony probation. And as the court pointed out when they litigated the defense motion to prevent these aggravators being added, the defense knew of these aggravators way back when. In fact, they had filed motions in limine and had argued these very aggravators. So they knew all the aggravators years in the past and had actually litigated on it, and there was no ambush. It was just the state meeting the technicality of putting it on paper that they are, yes, going to ask for these aggravators. And so I don't believe that this particular issue has any bearing on the case itself. In terms of the jail conversations, granted, the defendant's statements were open to 2 or 3 or however many possible interpretations of what he meant and what he was referring to, but that's a classic jury question. And the court did not abuse its discretion in allowing those statements in, and leave it up to the jury to decide whether or not they were relevant and whether or not they had any application to the facts of the case. It's a classic jury question. In terms of the HAC, the state's theory was slightly different than what Justice Labarga articulated. The state's theory was that Mr. Adams was in the other room eating cereal, and it's true that the evidence of that was a spilled bowl of cereal. But more than that, the cereal was actually found on Adam's shirt, indicating that he had been in the process of eating it and had jumped up and spilled it because it was on his shirt, dribbled down as if it had fallen when the police and the medical examiner found the bodies, indicating that something abrupt had happened. And it was close in time because the cereal was still there. Additionally, in terms of the HAC, and the court pointed this out in its sentencing order, both victims were beaten severely about the head. There were multiple abrasions. I believe Powell had 2, and Mr. Adams had multiple abrasions and cracks in their skulls from being hit about the head with a blunt force object, presumably the butt of a gun, but the medical examiner couldn't say for certain what did it. It's the state's theory that Mr. Avsenew beat the victims about the head to partially incapacitate them before he actually shot them. And so it was the fact that they were undergoing a beating. Mr. Powell was undergoing a beating. He was in a weakened medical condition because of his transplant surgery. And he suffered the blows and the incapacitation that might have come with that before he was ever shot. And there's no indication exactly when the shots occurred. As the court pointed out, all the shots were to the head and at close range. It's entirely possible that Mr. Avsenew incapacitated the 2 victims, and then when they were on the ground, shot them close range in an execution manner.
But counsel, I understand that. I mean, the competent substantial evidence standard is obviously a generous one, but I mean, isn't this kind of getting close to the line of speculation?
Less so with Adams, but definitely with Powell. I agree with you, Justice. And ultimately, even if this court gets rid of the HAC for one or both of the murders, it's harmless given the weighty aggravators that are in this case: multiple murders, CCP, and the fact that he was on felony probation at the time of the murders. Those are all very weighty aggravators, and the death sentence would survive even if this court strikes the HAC on Mr. Powell, for example. If there are no other questions, the state asks the court to affirm the conviction and the sentence in this case.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. I would remind the court of the exact nature of the constitutional violation in Coy versus Iowa. In that case, and I'm quoting from the opinion, a large screen was placed between appellant and the witness stand during the girl's testimony. After certain lighting adjustments in the courtroom, the screen would enable appellant dimly to perceive the witnesses, but the witnesses to see him not at all. It's the same circumstances we have here. The witness could see the defendant not at all. It's the same constitutional violation. And this is not a case involving child victims as Coy did, or as the case that the state relies upon, Maryland versus Craig. Maryland versus Craig is very narrow in its holding, applying it to small children terrified to be in the presence of the defendant. And it's, as I said in the reply brief, it's based on case law that was effectively washed away subsequently in Crawford versus Washington. As to the penalty issue of the death notice filed by the state says, well, there was no ambush. Well, that's not the standard. They have to comply with the statute. And they say that the significant proceeding was the arraignment. It's not the arraignment, it's the death penalty proceeding. It's the 921.141 proceeding at which the state is limited to, under the statute passed in response to Hearst, they're limited to aggravators as to which they give notice under 782.041B. So they had to comply with it. They didn't comply with it. They could have maybe gone in and asked for leave of court. They didn't do that. So they're left with no aggravating circumstances. So based on my presentation today and the briefs, I would just like to leave you with a thought, which all of you know, but it always bears repeating, that our Declaration of Rights and our Bill of Rights protect every person in the state and every person in this country. It's an inestimable benefit to the prosecution that the protection of these rights is left to the persons who our society might most despise. But nevertheless, all of us in the law are bound to see that these constitutional rights are fulfilled. So I will ask the court to reverse the conviction and sentence in this case. Thank you very much for your time today.
Thank you, counsel. We thank you both for your arguments. The court will now stand in recess for about 10 minutes before we take up the last case on today's docket.